Yes, Ramola, you can take over.
On behalf of the Indian Law Institute Kerala State Unit, I'd like to wish everyone who has joined us today a very good evening. My name is Ramola, and I will be hosting this session in the series of online lectures organized by the Indian Law Institute Kerala State Unit. Today's lecture is by Professor Sudhir Krishnaswamy on the topic Reservation Policy at Crossroads, the Supreme Court in 2022. Now I invite Advocate P.G. Jayashankar, member of the Executive Committee of the Indian Law Institute Kerala State Unit, to deliver the welcome address.
Thank you, Ramola. Honorable the Chief Justice Sri S.V. Bhatti, Honorable Executive Chairman of ILI, Mr. Justice Alexander Thomas, Professor Dr. Sudhir Krishnaswamy, Honorable Judges of the High Court of Kerala, brother and sister lawyers, a warm welcome to each one of you as we gather here today for a truly special lecture. It is my distinct honor and privilege to extend a heartfelt welcome to all of you for this lecture by the renowned scholar and the esteemed guest speaker, Professor Dr. Sudhir Krishnaswamy. We, the ILI Kerala State Unit, have been conducting online lectures to apprise and enlighten the learners and practitioners of law about various developments and advancements in law. In the world of academia, there are a few individuals who possess the ability to inspire, enlighten, and challenge our thinking. Dr. Krishnaswamy is undoubtedly one such luminary whose work and contributions have left an indelible mark on the fields of law, public policy, and governance. This lecture series is regularly followed by judges, lawyers, academicians, and law students. We, the ILI Kerala State Unit, is guided by its President, the Honorable the Chief Justice, and its Executive Chairman, Mr. Justice Alexander Thomas. I wholeheartedly welcome the President of the ILI, Honorable the Chief Justice, Justice S.V. Bhatti, who has given us unconditional support to all academic activities by the ILI Kerala State Unit. I also wholeheartedly welcome the Executive Chairman of ILI Kerala State Unit, Honorable Mr. Justice Alexander Thomas, who has always been a great source of energy, support, inspiration, and guidance for each one of us. Professor Dr. Sudhir Krishnaswamy is presently the Vice Chancellor of National Law School of India University, Bangalore. A Rhodes Scholar, he is the first alumnus of National Law School to be appointed as a Vice Chancellor of that institution. He has written on a wide range of topics on constitutional laws. To Dr. Sudhir Krishnaswamy, we express our heartfelt gratitude for accepting our invitation, and I warmly welcome you, sir, to this lecture. The lectures by ILI have proved to be very productive for both the lawyers and the law students. Honorable judges of this honorable court and the learned colleagues who are virtually participating in the events, as well as law students who are following this, I warmly welcome all of you to this lecture. To all participants, I encourage you to approach this lecture with an open mind, ready to absorb the pearls of wisdom that Dr. Krishnaswamy is about to impart. Let us engage in a lively discussion, ask thought-provoking questions, and actively participate in this intellectual exercise. Once again, a warm welcome to Dr. Sudhir Krishnaswamy and to all attendees. Thank you all for joining us today. May this online lecture be an enlightening and transformative experience for each one of us. Welcome all. Thank you. Ramola.
Thank you, sir, for that warm welcome. I'm honored to introduce our distinguished guest speaker today, Professor Dr. Sudhir Krishnaswamy. In addition to what Advocate Jayashankar sir had just mentioned, Professor Krishnaswamy is also the Secretary-Treasurer of the Consortium of National Law Universities. He is also a member of the Independent Oversight Board that makes content moderation decisions on Facebook and Instagram platforms. He's the co-founder and managing trustee of the Center for Law and Policy Research that engages in law and policy research, social and governance interventions, and strategic impact litigation. And he is also the founder of the Supreme Court Observer, which is the most reliable guide to the work of the Indian Supreme Court. Previously, he was the director of the School of Policy and Governance and professor of law and politics at Azim Premji University, and a professor of law at the West Bengal National University of Juridical Sciences, NUJS. He graduated with a Bachelor of Arts and Law degree from the National Law School of India, Bangalore, which he is now the Vice Chancellor, and completed a postgraduate and doctoral degree at the Oxford University as a Rhodes Scholar. He is a recipient of the Infosys Prize 2022 in the Humanities category. His current research focuses on constitutional law, the empirical analysis of the legal, political, and governance systems, and the regulation of new and emerging technologies, including artificial intelligence and automated decision systems. We are truly privileged, sir, to have such an eminent scholar address us today. However, before we begin the lecture, as you are all aware, today's session is being live streamed on our YouTube channel of ILI KSU and will also be available for subsequent viewing. I'd like to mention that there will be a short question and answer session at the end of the lecture. The audience may send in their questions to Dr. Krishnaswamy using the comment section on the YouTube channel. Now, without further ado, I pass the screen on to our esteemed speaker to address us on today's topic.
Thank you, Advocate Ramola and Advocate Jaishankar, for the gracious introduction. I'm just going to confirm that I'm coming through loud and clear, and before I push on.
Yes.
Yeah, thank you. Chief Justice Bhatti and Justice Thomas, I'm glad to be here through the ILI chapter in Kerala. I'm very glad to see the interest and the intellectual engagement of the ILI Center, and I think that this is not common across the High Court and across the professions. So it's remarkable that you're able to do this and sustain this. So I'm really happy that I'm a part of this and contributing to this effort. Thank you very much. Advocate Shyam Kumar invited me. He only needed to ask once he described what this occasion was about. I was glad to jump in and contribute. Thank you for the warm introductions. I'm going to take your permission and share a screen. I think it might help me both organize and give a visual element to the talk. So I'm just going to go ahead and share screen and confirm that you're able to see it. My computer says that you can see it, so I'll take it that you can see it. The topic that I want to address today is to look at reservation policy in the Supreme Court in 2022. Now, this is a topic that gathers a lot of public attention anyway through the newspapers, but I want to spend a little more time looking at the texture of these judgments and take a step back and assess whether we can make reach some broader conclusions, gain some wider insight into what might be happening in this space. While much of what I do is based at the National Law School of India, much of this presentation I owe to my team at the Supreme Court Observer, and a project that I've spent a fair bit of time, investing time and energy in, and I think vitally important for the future of the Constitution and the Republic in the 21st century. So let me jump in. I want to, in this presentation, look at 4 judgments of the court. And I think looking back at 2022, I on balance, I think these are the 4 most important judgments. The first 2, the Janhit Abhiyan and Patali Mahakal Kachi, are judgments that deal with categories of reservation, the conditions under which these categories may be permissible or impermissible under our constitutional regime. Jarnail Singh and the Nunes judgments both deal with partially categories, but primarily in the approach to reservation questions in 2 different arenas: promotion and PG admissions, especially medical education admissions, but maybe might have a broader ambit. I will first go through these 4 judgments and then try and develop some thematic questions that cut across the 4 judgments before I open up to questions. The EWS reservation judgment, I think, garnered pretty much the most attention in 2022. it was a new form of reservation, one that raised very serious challenges, constitutional challenges, and hence the court and the public were deeply engaged in the questions that this raised. So I'm not going to go through every line on my slide. I take it that it's visible and available to you, and so I will focus on some key themes. A 5-judge bench came together to decide this opinion. Chief Justice Lalit chaired the bench and surprisingly found himself in a minority as things turned out. The question before the court was whether the state more generically can offer reservation on the basis of economic criteria alone in the fields of higher education and public employment. That number was set at 10% for a category that was called EWS, economically weaker sections. And this was introduced, at least like some other recent amendments, through a constitutional amendment, in this case, the 103rd Amendment. Notably, the EWS reservation was not available to individuals who might otherwise belong to SCs, STs, and OBCs. So it was seen as a sort of exclusive reservation category. Not surprisingly, the case found the reservation initiative found its way to court, and several arguments were raised challenging this new category. 3 of them might deserve some special attention. The first is whether reservations could be based on economic criteria alone. Now, this is not a new question. This question arose way back when the Supreme Court addressed the question of reservations for the first time in Champakam Dorerajan. So it's not a new question. It's an old question. The court had taken a quite definitive view in Indira Sahni versus Union of India in 1992 that economic criteria could not be the sole basis of reservation. And this question was re-agitated in the EWS case. The second question was whether SC, STs, and OBC community individuals could be excluded from economic reservations. And the question of whether these are interlocking reservation categories or whether they are exclusive reservation categories. Sometimes we refer to these questions as vertical and horizontal, but that would be confusing in applied to a case like this, because SC, STs, OBCs, and EWS are all vertical categories of reservation. So the question of cross-eligibility came up in a novel form in this case. The third question was about the 50% ceiling limit on reservations. Our courts have not been very sharp about identifying reservations as a distinct form of affirmative action. While we have stated a 50% ceiling limit in the Indira Sahni case, and that limit has been in place again for a long period, at least 4 decades before Indira Sahni, the question of whether the EWS number, 10%, would breach the 50% ceiling came in for some sharp scrutiny. As we know now, the court split 3-2, but this 3-2 split is too simplistic a way to represent the court split, because it's not like they disagreed on everything. They disagreed on some things and agreed on some things. That all 5 judges agreed on a few of these questions. For example, on the question of whether reservations based solely on economic criteria are constitutionally valid, all 5 judges agreed. Justices Lalit and Justice Bhatt went as far as to say that the directive principle mandate might require that. So there's nothing wrong in creating an EWS type category. They didn't agree, however, on the question of breaching the 50% limit. So a horizontal EWS type criteria might have passed the standard for Justices Bhatt and Justice Lalit, but it didn't work out like that, and hence they said that the breach of the 50% limit was not constitutionally valid. Can SC/ST and OBC groups be excluded from EWS? Once again, the minority disagreed. And their position was that there was a nuanced argument here about the place of individual equalities and group equalities. While SC/ST and OBC reservations dealt with group inequalities, the EWS reservation dealt with individual inequalities. And so for the minority justices, there was no good constitutional reason to exclude SC/ST OBC individuals from the EWS category. Now, the majority also was a plurality opinion. There was no singular view, but just in the interest of time, I'm going to leave it on the slide and not explain it at any great length. The last question on which the minority on the bench took a different view was in the zones in which an EWS reservation might be made. They agreed that in the field of education, there was good reason to make an EWS reservation. However, in the field of public employment, since the court has insisted on quite sharp empirical basis, a demonstration of underrepresentation and disadvantage in public employment cases, that they found that this was not available in the EWS proposal, and hence they dissented. As you can see from the slide above, the majority 3 judges upheld the decision of the EWS proposal on almost all the questions that came before the court. So a 3-2 split, a significant decision, and I hope in later conversations that we have, a discussion that we have, we will have the opportunity to solicit more views and questions on this case. What is clear about the EWS case is that it pushes in a new direction. The reservation policy historically under the Indian Constitution has had a relatively inarticulate moral and historical basis, and the EWS case tests that previous silent understanding about why we have reservation at all. By moving reservation away from its old moorings, arguably this case opens up reservation in ways that we may only just be beginning to explore in the years ahead. Let me move on from the EWS case and move to the 1-year reservation case, which went not before 5 judges, but before 2 judges. And the question in the 1-year reservation matter was slightly different from the Maratha reservation case, which turned on who could identify backward classes and subclassifications within the backward classes. It was a question of whether the state governments had this power, which required the 105th Amendment Act in 2021 to clarify that the states indeed have that power. But the second question that they had here was whether the Vanyars as a community could take the benefit of being described as a most backward class in the context of Tamil Nadu reservations. The arguments in this case were sort of familiar. The first argument is that the TN government did not have the power till the 105th constitutional amendment to pass the act, and hence it couldn't be applied retrospectively. The second is that subclassification discriminated against other MBCs. And the third is a familiar argument in these sorts of cases, which is that insufficient empirical data was provided by the government to support the claim of backwardness. It's important to ask what the standard of data in such cases must be. The courts are less than clear and slightly inconsistent across time, but that's an issue that we will come back to. The way the court went, and please, and I think those of you who are familiar with this area will recognize that there is a question of subclassification in the OBC category and a question of subclassification in the SC category, and the court has taken a slightly different view on subclassification within these two categories. So as far as OBC groups are concerned, the court has for some time allowed subclassification so long as reliable data is provided. In the case of the SC group, it's less than clear whether subclassification is allowed. The problem that the bench had with this particular intervention was that inadequate data and antiquated data was produced to make an argument for 1-year reservations. And hence, in the absence of good data, that this should be regarded as a violation of Article 14 and 16. Now, coming on the back of the Maratha judgment, which we have seen in the previous year in 2021, we understand that the question of the adequacy of data and the standard to which data must be produced is one that is one that trips up several state initiatives in this field over time. The third case that I want to focus on is the reservation in promotion case. You'll notice that Justices Rao and Gavai are sitting in this case just as they were in the 1-year case, and Justice Sanjeev Khanna joins them to form a 3-judge bench in this matter. Now, reservations in promotion, which is set out in the Supreme Court corpus most extensively in the Nagraj case. And in the Nagraj case, there are 3 controlling conditions that the state must meet before reservations in promotion are provided for the SC/ST. First, the state must show the backwardness of the class in the particular position service cadre, and it must show inadequate representation in that position of service, and it must show make a broad argument that this is in the interest of that the overall interests of administrative efficiency are protected by some form of testing or some form of ensuring that qualified people occupy positions. So the Nagraj opinion was sort of controlling in the field, but several gray areas came up. And one of that was whether the Nagraj opinion, by showing the demonstration of backwardness of the SC/ST community, misread and misapplied Indira Sani. Because Indira Sani's backwardness criterion was primarily focused on the OBC question, bifurcating SC/ST reservation category from the OBC reservation category, thus establishing 2 standards even within the reservation categories. This question came up in the Jarnail Singh case, and the Supreme Court struck down the backwardness provision from Nagraj. So this much we understand, but the problem that emerged in these cases is that the creamy layer exclusion principle was extended to promotions, and as one can understands, both in the democratic arena as well as in the administrative arena, this generated a lot of heat and dust, resulting in an approach to the court to clarify what position should be taken in these matters. Now, in 2022, the court offered a range of clarifications on how these kinds of assessments, that's Nagraj read with Jarnail Singh, and clarifications, how should this be read? And it provided a range of clarifications, which, at least to my mind, on our first reading, is productive of more litigation rather than less. The first question before the court was, what was the yardstick that one should take to arrive at quantifiable data on the inadequacy of representation, to which the court reached the conclusion that this should be done on a case-by-case basis. At what level and what unit should this be assessed? The court said that this should be done at the cadre level. can the proportion of the population of SCs and STs be used to assess inadequacy? Determined by every state on a state-by-state basis. Should it be done periodically? Yes, should be done periodically, but government may determine what periodicity. And how should data be done? Should it be done by sampling methods or otherwise? And the court said, no, it should be done at each cadre. And it should be done at the cadre level, not on a sampling of government officials as a whole. Any quick read of these conditions by delegating and punting the question to the state governments and by allowing for case-by-case assessments, the courts were effectively requiring governments to do what would be rather challenging and difficult assessments. Let me move on now to the fourth of the four opinions that I want to focus on, which dealt with PG NEET examinations. Chief Justice Chandrachud sat on the bench, as did Justice Suryakant. And for those of us who are in the south of India, we know that NEET examinations are productive of much heat and dust and much political action. PG NEET examinations are rarefied as they are not immune to kind of deep litigation. And so this case is no surprise. Earlier in 2021, the NTA issued an admissions notice allowing for reservations for students under the All India quota. There were already reservations for SC/ST, but the 2021 notification introduced reservations for OBC students and EWS students at 27% and 10% respectively. Now, there was some kind of idea that the All India quota was somehow meant to be free from reservations or something like that. And so at every step, introducing new reservations has come to be seen as somehow remarkable and tested in court. What is the question before the court? The first question before the court is a familiar one. OBC reservations are reverse discrimination against general category applicants. We have seen that argument being made before. The second is that the added reservation crosses the 50% limit on reservations generally. There's some confusion here about what are horizontal and vertical reservations. The 50% limit really applies to vertical reservations, but again, we don't have clarity either in Indira Sawhney. Maybe in some subsequent cases, the court has spent some time on this horizontal vertical question, but confusion keeps arising about where that 50% limit applies. The next question was whether there was enough data to show that OBCs are backward in the context of PG NEET admissions. And the third was to challenge the EWS limit, which is similar to the non-creamy layer limit at 8 lakhs. So these kinds of questions came up before the court. As I've suggested to you in my brief summary, some of them seem to be rehearsing previous arguments that have been discounted by the court, but nevertheless came up in this case. Not surprisingly, following past precedent, the court upheld the OBC reservations and said that it's not incompatible with merit and so on and so forth. So that is the not surprising part. Now, the idea that the All India quota was created to be free from all reservations, the court clarified that it was only domicile reservations, that is state-based reservations, that were disallowed in the All India quota. All other reservations, that's SC, ST, OBC, EWS, would apply. The third question about EWS reservations and 8 lakh income limit was passed over onto a different constitution bench in the EWS challenge. We have looked at that separately. Surprisingly, while we have cases that look at the question of data quite carefully and can be quite sharp about it in the OBC matters, in the EWS matters, we haven't seen any real data being produced on the 8 lakh income limit and the nature and the basis of that reservation. So let's look at all 4 of these cases together. You'd notice that one of the sharp elements of adjudication on matters in Indian courts is that even within the Supreme Court, there is very little commonality in the benches that decide similar questions. Now, we know that the Indian Supreme Court doesn't sit en banc. It sits in benches, and bench composition is left to the Chief Justice as the master of the roster. Even so, the absence of a structural fix on similar cases going to a similar bench generates a discordant view from the court on a case-by-case basis. And a very simple look at this picture set gives you a sense that except for the commonality between Justices Rao and Justices Gavai, you get a different set in every case. What can we learn looking at all 4 cases together? So I think 2022 was a very important year because it to my mind at least, after the 1950s with the Champakam Rajan case and the early testing of the concept and purpose of reservation, and arguably Indira Sawhney in 1992, 2022 will become the most important year in the future of reservations. The reason for that sort of a claim would be that the purpose of reservations itself has now become unmoored from its fundamental goal, which was to correct historical disadvantage. Now, we have advanced 2 kinds of justifications for SC/ST OBC reservations. The first is historical disadvantage and correcting them. The second is ensuring that diverse social groups, especially disadvantaged social groups, participate fully in public institutions and public education. Now, with the EWS category in particular, we are moving towards a model of reservation that would look at income redistribution, poverty alleviation as being reasonable and acceptable justifications for reservation. Here I want to make a second point, which is that reservation is an aggravated form of affirmative action, meaning that affirmative action can take many hues. Affirmative action can include scholarships. Affirmative action can include free coaching programs. Affirmative action can include other forms of income support relating to education. Reservation is the sharp edge of the affirmative action instruments. Now, by suggesting that general income redistribution goals, poverty alleviation goals can be tackled by the reservation instrument, we move to a different stage in the place of reservation in the Indian Constitution. If this is allowable, then one can see new demands for reservation flooding in from many corners, which would all be reasonably legitimate demands under the new standard. Second, the question of who are the beneficiaries of reservation? Now, whether we should subclassify, microclassify caste groups into MBC and maybe further backward class or SC subcategories as the beneficiaries of reservation. Now, we tend to think that Indian political life, and I mean here democratic political life, has fragmented to address the interests of microcaste groups. So today, every caste group, even a modest size caste group with 2 to 3% population size at a constituency level, can make group-based claims in the political arena. It appears that very quickly those group-based claims in the political arena transform into legal claims in the constitutional arena for reservation. And the court, though in the Vanyar and Maratha reservations cases have not allowed an easy transfer of the language of extreme backwardness into the political arena. Those following politics across India, including in my state, in the state of Karnataka, can tell that there's going to be serious pressure on the question of subclassification in the years ahead. It might well define the next 25, 30 years. And 2022 will become a key year when we look back in time. The last point that I want to make is the complete confusion in the court on what is reliable data. It seems that the court has different standards depending on the question at hand. Is the standard the same for EWS and OBC? Is the standard the same for OBC and MBC subclassification? And so on and so forth. For those of us who have worked through and tried to understand the Indira Sawhney case, we understood that the court established that there must be academic rigor to the making of these standards. And second, that while academic input and rigor was necessary, that the state could make some reasonable adjustments to that academic rigor while making and developing categories. It is useful for the court to restate and reclarify that standard. Today, the levels of contemporariness required and the levels of accuracy and rigor in the data required are up in the air, leading to several parallel claims and disparate decisions arising out of different benches. So let me close with that. I mentioned the Supreme Court Observer because I've spent much of my time reading these cases and writing about them in this platform. I will stop for the moment and stop sharing and invite you to take a look at our work at this space and open up for questions. Back to you, Ramola.
Thank you, sir, for that very interesting session. We have a few questions for you. So if I may just read them out to you and you can answer them one by one.
Please.
So the first question that I've received is, in the context of reservation and promotion, the court has specified a case-to-case examination and that the assessment of inadequacy in each cadre. Now, individually, wouldn't that create more confusion and more arbitrariness instead of really meeting the end goal of uplifting, probably say, people in that category?
I think that's a great question because what we are not bringing to the table is a discussion about the quality of government data. For those of us who worked with government, we know that if you asked even broad questions, like what is the representation of X community in government teachers, for example, I don't even talk about subdivisions, just all teachers in government employment. Government simply does not have access to this information. So the question is that if we are going to push in the direction that such information needs to be produced, then government would either have to invest heavily in the creation of new data systems or as the basis of these decisions. But today, the pushback in the court seems to be that government must produce accurate data and at the cadre level. And this is a serious challenge that I'm not clear that governments are going to meet in any substantive way.
Right. Thank you. So in the context of the EWS judgment, what is your take on the approval given by the Supreme Court in this permission to breach the 50% limit, so to speak?
So the court had previously taken a very serious view of the 50% limit. And so as some of us are familiar, that states like Tamil Nadu have had to place a statute in the 9th schedule of the Constitution to protect it against constitutional challenge by raising the limit above 50%. Now, there are some who argue that the 50% limit is a fictional one and is misdirected in any way and so on. So there's no great loss if we give up on the 50% limit. But I suspect that the EWS judgment, the majority judgment, had the most ingenious solution to this problem. It said that this was not a breach of the 50% limit because the 10% was a 10% in the general quota. Now, does that mean hereafter that the general quota can be further subdivided in various ways that respond to various felt needs of the time? And my prediction would be that that is precisely the direction that reservation policy will go. If 10% EWS is possible, then I'm sure that there are other legitimate claimants for subdivision of the general quota, which would make a mockery of the 50% limit. Then the court may as well give up on the idea of a 50% limit and articulate a new normative limit on reservation, because the EWS decision blows it away anyway, only on SC, ST, OBC reservations at the moment. So not a limit on anything else.
Great. Thank you. Now, the last question is a little bit more general. So the question is reservation a fundamental right? And if it is, does it or does it not require a shelf life in an egalitarian society? What are your takes on that?
So I think the court has been very clear that reservation by itself is not a fundamental right. It's been drafted into the Constitution as an exception or an enabling provision to realize Article 14 and 15 and 16 and so on and so forth. So I don't think there's much confusion on the constitutional status of reservation as a fundamental right. But the second question is more important. Is there a shelf life? Now, I think that there are two ways of going at this question of what are the appropriate limits to reservation. One is to set arbitrary time limits. The other is to set some goals of substantive equality that should operate as functional limits on reservation. So as those of us who have followed this space very closely over many, many years, we know two things. The Constitution initially had a 10-year limit. It was not a meaningfully thought through limit, but it was there, notionally there, and then was done away with. But isn't the relevant question why we have not taken out any caste or community from the SC, ST, OBC list? I think that if we are able to agree on what are relevant moral criteria and empirical criteria for the inclusion and exclusion of groups, we can circulate groups in and out of the SC, ST, OBC categories, and then not focus so much on time. That we can understand that because we have a fundamentally stratified and historically hierarchical society, that it will take some period of time before we can achieve substantive goals of equality. So we don't have to focus on an arbitrary limit of time, but we should develop an empirical threshold by which groups may be included or excluded from the categories. I think this is a much more morally defensible position and one that we might think through carefully.
Yeah, I think that rolls back to your point about reliable data and how to get that. Yeah. So though that comes, so now we come to the end of our session today. But before we end, I must mention the people who made this event possible. First and foremost, of course, our esteemed speaker, Dr. Krishnaswamy. We are immensely grateful, sir, for taking the time out from your very busy schedule, especially you're not even in Bangalore. So we are extremely grateful for that and for sharing your very valuable thoughts on this contemporary issue. I must also thank the Honorable Chief Justice, Mr. S.V. Bhatti, the President of the ILI Kerala State Unit, for his unwavering support in all of our activities. I also thank Honorable Mr. Justice Alexander Thomas, the Executive Chairperson of the ILI Kerala State Unit, who is truly dedicated to ensuring the success of ILI's online lecture series. I also thank Advocate Sanjay, the Secretary, as well as all the other members of the ILI Kerala State Unit for their meticulous planning and organization that culminated in today's lecture. I must also mention my gratitude to the staff of the High Court who ensured that the event was streamed without any technical issues. Lastly, I thank the judges, lawyers, academicians, students, and other members of the audience who have joined us virtually to make this lecture a fruitful experience. Thank you all. And with that, we have come to the end of today's event. I wish everyone a very great evening.